The Law and You. A look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You. Presented by lawyer P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation building series, The Law and You. This is program number 966, coming to you on Monday the 9th of March 2020. On this program, I will speak to you on the topic evidence of material contribution. And I begin with my usual preliminary comment of expressing condolences to all families which have suffered recent bereavements, and in particular, those families who have suffered bereavements as a result of violence. And in that connection, let me express once again my horror at the news of yet what appears to have been another killing of a woman at the hands of a man. Seems that human life counts for very little in this country, particularly since the Privy Council practically abolished capital punishment when the Privy Council said that you cannot hang anybody for murder unless it was the worst of the worst. And I said at the time on this program that that decision by the Privy Council practically put an end to capital punishment, and so said, so done. So it seems that the life of a murderer is more sacred, more important, more precious than the life of that murderer's victim. That appears to be the theory behind the refusal to use the death penalty, which the Privy Council has practically imposed on this country and other countries. It is sad. But practically life in St. Vincent and the Grenadines these days counts for very little in the eyes of some persons. And when the victim of homicide is a mother, the murderer is rendering motherless the children of that woman who is killed. But we appear to like it so. Sad. Now to the topic, evidence of material contribution. I say this in the context of the rules of evidence which require a person claiming to have an interest or a share in property has to establish that claim in a court of law according to evidence tendered by that person or by witnesses on behalf of that person who is thus claiming. The context in St. Vincent and the Grenadines is usually the case when a man and a woman have been living together unmarried and either the man dies or the relationship breaks down in his lifetime and he chases the woman away. And she is then burdened with the responsibility of proving that she had made a material contribution to the assets of that relationship. In the vast majority of cases, the single most important asset of the relationship would be a dwelling house. Increasingly, women who decide to live with a man in a common law relationship face humiliation from either the man, if he lives and chases her away, or from his relatives if he dies without having made a will. There are cases where a woman in a common law relationship loses the common law spouse through death, attends the funeral, and while the funeral service is going on in a church, relatives are already in the house in which that woman and her common law spouse lived, drogging out this, that, and the other, and in some cases preventing the woman from coming back in the house when she is coming from the funeral with all her belongings in the house, saying, you ain't coming here because this house belonged to my father or my uncle or my brother. You ain't have nothing here, so go by your business. That scenario is not infrequent in this country. Fortunately, the authorities have announced that there is some legislation being prepared to safeguard the interests, the rights of common law spouses. So that where relatives are claiming that a woman who lived with a man, not married, hasn't got anything either in the property or anything to get from his estate, he having died, or where a man chases a woman away, the relationship breaks down and he says, look, get out of my house. The woman who wants to establish her rights will have no choice but to go to court. We await the advent of that legislation to see what provisions are made. But I suspect that in keeping with legislation of a similar kind in other parts of the world, the legislation would provide some avenues by which it would be easier for the woman to establish her rights in property belonging to, or formerly belonging to her and her deceased partner, or her partner who has chased her away. Hence the topic of this program, evidence of material contribution. Now, the word material there means serious or significant or valuable, as opposed to ephemeral, flimsical, non-essential, non-consequential assistance. So that a woman who lived with a man in a common law relationship is not entitled to claim a share in the house if she met him at the house and all she used to do is to help him take care of the house. The law would not regard that as a meaningful, significant contribution towards the acquisition or improvement in the house. In other words, the law would not say, well, you help him look after it, you kept it clean, and therefore you made a contribution towards the value of the house. No. So material means serious contribution, which the law would recognize as rendering that woman entitled to claim a share in the house or in the property. Let me say parenthetically that the same might apply if the roles are reversed. If it is the man who has assisted a woman in building a house or in improving the house and in a non-marital relationship, and the woman chases the man, the same principles apply. The law does not draw a distinction between which of the sexes is behaving in that manner. So the law would apply to either a woman who is bringing the claim or a man who is bringing the claim. But because in the vast majority of cases, it's the man who is alleged to have been taking advantage of a woman, or the man's relatives who are alleged to have been taking advantage of the woman, and women are therefore the victims, I will continue to use the example of a woman as the claimant. But I don't mean to imply that it is only women who can be claimants. For years, and the law anew is now coming towards the end of its 22nd year in April, Divi. Next month, the law anew would be 23 years old. So for years, I have been saying and repeating that where your position is vulnerable, in other words, where you are likely to be taken advantage of, you must be sensible and take sensible precautions to preserve the evidence which could help you if you find yourself, or if you should find yourself at some stage in court having to establish your right to an interest in property. So that where you spend your money to buy building materials or to pay for the services of workmen and so on, get the receipts and put them up. Store them with a relative or friend in case the man is of a wicked disposition and is likely to stir up and look and hunt and find your material, your receipts for materials, and destroy them. But keep your receipts. Receipts provide good evidence of your expenditures so that when you spend money and you get a receipt and you put that up, if you have to go to court, you give your lawyer those receipts and the lawyer would be in a much better position to fight your case than if you went to a lawyer and said, look, I bought blocks, I paid workmen, paid for people to drag sand and this and that, and I made this and that contribution, and you have no evidence to give to the lawyer as proof of what you put into a dwelling house. And it becomes a case of your word against the man's word. And you run up against the principle of law, which says that he who alleges must prove. In other words, you have the burden of proof. You have the burden of proving the case which you are trying to establish before the judge. Because if you bring a case in court, the other side could simply sit back and fold their hands and say nothing. You have to prove your case. And you can only prove your case if you have evidence to back up what you are saying. So that if you go to court without the necessary evidence, without having good proof, you are likely to lose. Because the judge cannot decide a matter based on your good looks. The judge can only decide a contested matter based on the evidence which you tender in court to prove to the judge the truth of the things you are alleging orally. In addition to receipts, if you have bank statements, or better still, bank books, well, in the days when they had some things called bank books, these days the banks appear to have got rid of the old good old-fashioned bank books where you could look and see what you put in and what you took out of a bank account. But if you have your bank statements and you keep them up and put them up, and a dispute arises as to what contribution you made to the building of a dwelling house or the improvements to a dwelling house, that would stand you in good stead if the matter goes to court. So apart from receipts, bank statements would be good material evidence on which you might be able to reply. Of course, a bank book doesn't show what you spend money for. All it can show is that on a certain date you withdrew a certain amount of money from the account. Nor does the bank book show or the bank statement show where you got the money from that you deposited. But at least it will show that you deposit money, so that if you used to get money by Western Union or MoneyGram from a friend or relative abroad, and you put that in the bank, at least the bank will show, the bank statement will show certain monies were lodged into the account from time to time. So together with the lodgements and the withdrawals, you could then use that to support a case that, yes, you used to get help from your brother in England, and that when you withdraw these lump sums from time to time, you used it to spend on the house. Then you can provide evidence of contribution by the oral evidence of those who worked on the house. Not as good as receipts or indeed bank statements, but if you could bring along a carpenter or mason or truck driver to prove that, yes, you paid him for carpentry services or for masonry work or for jogging things in the truck for you, bringing rabica and sand and so on, then the evidence of those persons could assist if the evidence is believable. Because the judge is smart enough to know if you are trying to trick him or her. If you have set up these people to come and give false evidence on your behalf, and anybody who comes to court and gives false evidence, that is evidence which you know is not true, you run the risk of going to jail on being convicted of perjury. So don't let anybody carry you to court as a witness to tell lies. Dangerous. Otherwise, when you are languishing in jail, they don't have you to study, they wouldn't even come and visit you. So don't go to court and lie for anybody. Once you go to court and you take that Bible and you swear by Almighty God to tell the truth, the whole truth, and nothing but the truth, that is what you should do if you are called as a witness in any case, be it civil or criminal. But don't let anybody get you to make up a story and go and take an oath and tell lies on oath. Don't do that at all. For one thing, you would hardly fool the judge. And when your witness is cross-examined by the lawyer for the other side, it won't be long before the gaps and the inconsistencies in that lying witness's testimony are revealed. And then, not only would the lying witness get into trouble, you would get into trouble as well for having conspired with the person to go and tell lies and commit perjury in the court of law. But once such evidence is truthful, then the evidence of people who actually worked on the building or from whom you bought things, there might be a fellow you bought blocks from who might be able to testify that, yes, you came and you bought blocks with such frequency and so on, and roughly how much. I mean, if you don't have receipts, you may have to simply rely on testimony of that kind. So people who supplied materials for you at your request and upon payment by you, those persons could be brought to give evidence on your behalf. But in all cases, you must have credible evidence to prove that you contributed to the building of a dwelling house. Quite frequently, parties live together, and when they begin, they get a house spot either to rent, or one of them is given permission by a relative to occupy a house spot, or they might even squat on crown lands, government lands. And then they start to put up a structure. The old people used to call it 4 sticks, but put up a structure on the land These days, nobody bothered to go and dig posts and put on posts and build a house made of timber and so on. These days, everybody is looking to put up a permanent structure, a wall structure, which you really shouldn't do. If you're renting land, you shouldn't put anything concrete on the land except some bare posts and probably concrete steps, because when the time comes that you have to give up the land, you may lose whatever you have there, unless you got permission. And if you're renting land and you want to put anything permanent, try and get the permission of the landowner in writing, so that later on when the landowner dies, his children or beneficiaries don't deny and say, no, you never got permission to put a wall house. And you will say, yes, you gave. To avoid that, agreements should be in writing. It don't have to be anything done by a lawyer. Normal sheet of exercise book paper. Once it has on the names of the parties, the addresses, the date, and the substance of what is being agreed and signed by both parties and witnessed, that is normally good enough. Of course, the best thing is to get a JP, a Justice of the Peace, to witness such an agreement, or even to draw it up himself. And I've seen things prepared by JPs which are very useful. But if you go into a venture with somebody to either build a dwelling house, and you're not married to the person, and you have no receipts, no bank statements, even slips from Western Union or from MoneyGram, the evidence of monies that you received, even those would help. But if you have nothing at all, then you have no evidence that you have made a material contribution towards the building of that dwelling house. And your position becomes a weak one. You are vulnerable. That is, you are liable to be taken advantage of by not having evidence of what really happened. And as I said before, you have situations where if your partner dies before you, his relatives are going to come and want to chase you out of the place and say you have nothing there, that it was their relative's house and he is now dead, and go by your business. And you don't want that to happen. Of course, the best thing you should do if you're in a common law relationship and it is possible, the best thing you can do is to get married. And once you are married, you're a lawful wife, then the law will be on your side as a lawful wife. But if you're just a common law wife, it just deal with you, then you really have no security. All right? So please address your mind to having evidence that you made a contribution. And final piece of advice I want to give: if you are in a common law relationship and your partner gets sick, and is likely to die, do not hesitate to go to a lawyer for advice, and the lawyer may advise you, look, let us get something drawn while the person is still alive, because when they're dead, they can't sign anything. So even if nothing was said if you don't have any evidence during the time the house was being built, if your partner takes in, go and get a lawyer to draw up papers. Your partner can, even if your partner is too sick to sign, arrangements can be made for justice of the peace to go there with a document, or for an official attestant to go from the courthouse, a deputy registrar, and speak to the person if they are capable of understanding and say, Mr. So-and-so, is it true that this house belongs to you and this lady? And the person may be conscious enough to say yes. And once a person understands what is being asked and they give their consent and the document is read to them, that would stand up in court. But if you have nothing at all, then crap or smoke your pipe. And you should be sensible enough to secure, safeguard yourself and your children from unscrupulous, wicked persons who are going to say you have nothing there. You didn't make any contribution to a dwelling house. All right, I will continue in that vein from time to time, but that is all from this topic and on this program of The Law and You, program number 966. I look forward to being of further service to you next week, Monday DV, for another presentation in this public service nation-building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.